deep inside, there's a huge part of me that's gone.
The horror is once you get out, trying to get back what you've lost.
When you're on that side of the bars and there's no way, there's no hope, there's no crack, you give up.
Took away a big portion of my life, took away my life with my children.
I mean, what happened to the word investigation?
Helpless, fear, anger, and revenge, and wanting people to be held accountable for what had happened to me.
And why? Why did you do it? What possessed you to play God?
I knew my life was over right there.
Having my family taken away, everything taken away from me.
I had my life stolen away for 25.5 years for a crime I didn't commit. You can't get that time back.
Hi, I'm Kelly Vanson.
And I'm Kelly Lozo.
And this is Real Life Wrongs, where we dive into the stories, the crimes, and the hard times of the complicated world of wrongful convictions.
Episode 12. What John Knows. Guest, John Hill.
John Hill was originally a guest on our lawyering episode, but after speaking with him, it was clear he needed his own episode. In our conversation with John, he covered so many topics. His life experience is remarkable. You'll find so many gems in our conversation with John, from understanding the prison system to his childhood that led to his life as a lawyer, and marginalization, which is a biggie. But also, John wrote Box Parole. The main story begins with convicted murderer Terry Fitsimmons, who hanged himself in Ontario's Kingston Penitentiary. John delves into his background and the senseless killings which occurred after spending years in isolation. John attempts to defend the indefensible by putting the blame on the prison system for creating a monster. So if you want to know what John knows, grab a seat, a coffee, or something stronger, and have a listen. It's really an honor to speak with you based on your experience. And like I said on the phone, it wasn't me, it was Kelly who said, that's an individual who's, I think, was it seen too much or knows too much?
Why not both?
Yeah.
What is it like to have had a life with your experiences in it? Did you ever think, going into law, that this would be your life?
Well, quite frankly, I didn't expect to be a lawyer at all. It had sort of stumbled into it. And then when I got my law degree, I had a general practice for 10 years. But what got me involved with it was that I was dealing with psychiatric patients at the St. Thomas Psychiatric Hospital. And from there, I developed this feeling that things just aren't right in the judicial system. Fortunately, about the same time, Professor Ron Price from Queen's phones me up and asked me if I would consider leaving private practice and becoming director of the Correctional Law Project at Queen's. That got me into dealing with students, dealing with inmates, dealing with problems that I certainly didn't deal with in private practice. And after I finished up my academic career, I went back into private practice, but decided to concentrate on what I would call high-end criminal cases, being murders, major drug conspiracies, and so forth. And then with continuing with prison law practice. So I've spent basically 40 years doing that.
So just for listeners who wouldn't know, what specifically is prison law?
Prison law is where you represent an offender after they go to prison. And a lot of people think that once you're in prison, you throw away the key. Unfortunately or fortunately, prisoners retain all the rights of an ordinary citizen, save and except those rights that are taken away because of their incarceration, which means nowadays they have the right to vote. They have the right to be treated humanely and ethically by the system. And that becomes a big problem area with the corrections. They've always been doing it this way. How do we do it with the way that maybe the court should tell us how it's done. So that led to a lot of lawsuits and a lot of test cases to find out exactly what prisoner rights are. And I think I've quite enjoyed my life in the law and finding out just what that involves. And as a result, I've had a lot of cases that I've won, and I've had a lot of cases that I've lost. But it's been a very enjoyable career.
Have you seen a lot of progress in that area of treatment of inmates?
Well, let's say it's better now than it was. Is there a lot areas where it could be improved? Absolutely. But I think that when I think back to what they were doing years ago, I remember when I was at the Correctional Law Project, dealing with a warden who thought it was all right to punish an inmate by hog-tying him to his bed and leaving him there for protracted number of hours. We were able to step in and threaten a lawsuit there and got that policy established. But there's been others that have taken years and years to correct. And that's one of the reasons in my book about Terry Fitsimmons, we got into a situation where a fellow was released directly to the street after serving 6 years in solitary confinement. The Terry Fitsimmons case was the first case where we actually brought evidence of Harvard professor Dr. Stuart Gracian to the court to show what the effects of solitary confinement are. And then Gracian's work was used again in the Arbour Commission study in the prison for women, and it was used right up to the BC Civil Liberties case, where ultimately solitary confinement was deemed unconstitutional. So some of those, it takes a long time to go, but others, it can be resolved in a phone call. Sometimes it takes a lawsuit. And I've been doing a lot of lawsuits as well against the Attorney General and Her Majesty the Queen and Right of Canada.
Are there examples where certain treatments, mistreatments, I don't know how to say it, are necessary?
Well, from the correctional officer's standpoint, yeah, they don't have to put up with being abused. And the old way of thinking was, throw them in the hole. But I think that there are better ways of dealing with it. Trying to figure out why an offender is acting the way he is, disruptively. And then there came about building actual ranges where people who were always misbehaving could be segregated, but still not put in solitary confinement. So that there has been, I think, an increase in the way that they look at offenders who misbehave. The other thing that will happen is that because the inmates do have rights, when they misbehave in prison, they can be charged institutionally and go before an internal disciplinary court. The court is usually provided over by what they call an independent chairperson. A lot of inmates are skeptical of that and call them the dependent chairperson because the decisions often reflect what the warden wanted anyway. But nonetheless, if the dependent or independent chairperson makes a ruling that's against the law, then that can be challenged by way of judicial review. So again, brings the law into the system, and very often those misdeeds at that local level get resolved once it's taken to the higher level.
Right. Now, just in terms of the subject of your book, who would actually think it's a good idea to take someone who's been in isolation and just simply release them?
Well, that's a question that we had to ask. I was criticized when I was at Queen's for going before a parliamentary committee and testifying that the decision to implement a detention system, that means keeping the person until the warrant expiry date beyond when they would ordinarily be have statutory release, was a good thing in certain circumstances, when it would be a horrible thing for somebody to walk out into the street not prepared for release. I have had clients who was released to a halfway house. He was afraid to go out the door. He'd been institutionalized for so long that he got to a stop sign. He didn't know how to cross the road. That's the degree of deprivation that an inmate suffers in long-term incarceration, let alone isolation. When you are in a solitary cell, locked up 23 hours a day with no other human contact, we know ourselves, just going through the pandemic, what a strain it was to be lack of social contact for a period of time, whether it be days or months. Now, imagine that you were asked to be kept in a washroom with no bigger than with maybe some sort of soft cushion on your bathtub. Could you think you could survive the lockdown of the pandemic in that condition? Now, take that and multiply that by 6 years, and you can understand what kind of horrendous suffering these people go through. And it's not physical, it's mental.
For sure. And it seems to me, that the mind has been absent from the system. It's kind of like you go to jail, you're a piece of meat. And as you said earlier, without ever asking the why, yes, there's a wrongdoing. That's what got you here, but it does seem absent from the whole process. So have you seen improvements there?
The real intent of my book is not as a crime book, not the who did it, when he did it, why he did it. It's the why he did it, and that's what I wanted to stress in the book, is that why someone would act out the way he did. Now, certainly not everyone who gets out of solitary confinement goes on a killing and bank robbery rampage, but there are examples, and the fact is that solitary confinement can have long-term mental effects, and we are the people on the outside that suffer when that kind of ill treatment takes effect.
I can't even imagine it's a question of, would someone in solitary have, would there be an impact on that person psychologically? To me, that's not a question. It's yes, it will.
Well, I think as I said before, under the pandemic, I think we're all getting a little bit more used to what toll it will take. But, there's other areas where solitary confinement takes effect. When prisons look for drugs, people come back off of temporary absences or so forth. They will sometimes say, okay, you're going to a dry cell because we think that you have secreted harmful substances in your body. And then they're kept in there. Again, maybe nothing happens. But no reasonable and probable grounds to believe that they have it. But we'll just check to make sure. And for women inmates, that is even more dangerous, because they will be kept in until they complete a menstrual period. That it could be a lengthy period of time. And again, all the suffering that somebody goes through in solitary confinement comes to pass again, and without reasonable and probable grounds that someone is secreting some substance.
So, John, you also, before we began, you mentioned various ways that wrongful convictions come into play here.
Mm-hmm.
So I don't know if we can sort of revisit that.
Sure. Well, I sort of made a list in preparation for our talk today. Things that I've come across in my practice. One would be incorrect forensics. I had a client who eventually was exonerated as being wrongfully convicted. And she was convicted on the basis of Dr. Smith's evidence that she had abused her infant child and had beaten him and resulted in his death. The client was Tammy Markart. She was a wonderful lady and always presented when I interviewed her as a really caring, loving human being. What really set me off in the Tammy Markart case, the reason I asked that to allow me to recommend her to the what we call now the Innocence Project was that she'd come in and she was really highly stressed out. She had been a participant in the kitten program at Grand Valley Institution. Grand Valley had this program where a veterinarian would provide basically motherless kittens to inmates, and they were there to feed them bottle milk and so forth and look after them until they could be raised to look after themselves. And Tammy came in and she was totally upset because her kitten had died. And I couldn't believe the amount of stress that this was putting on her. And then I thought to myself, if she was feeling this much for an abandoned kitten, what did she feel about the child that was taken away from her? All the children were taken away from her. This was a horrible situation for her. So I recommended it to the Innocence Project, and eventually she was found that the testimony of Dr. Smith was inappropriate and that there was no basis on which to find her guilty. So she was exonerated and eventually got a small sum, I think a totally inadequate sum for her experience of losing her children and spending years in prison. So it was totally on the fault of the court believing a doctor that came in and gave wrongful information. And
it's interesting, John, because just before jumping on with you, Kelly and I are recording one of our episodes, and Tammy is the subject of that. We also know Maria Shepard, and Kelly knows Maria quite well. We've spoken with Maria and Jordan. So we're very aware. Kelly always jokes that when she's teaching at Carleton, she uses air quotes when she speaks about Dr. Charles Smith.
Yeah. And my students are not allowed to refer to him without the air quotes.
Okay, good for you. I did a murder trial up in Bracebridge one time for a Black inmate. And one of the questions was whether or not he had come into the house. And what they were using is footprints and blood from someone wearing socks. And they were saying, they got an expert there to say that those footprints matched the impressions he would make. Total junk science. Fortunately, we were going to get that sort of taken care of. But a defense lawyer always has to be on guard because there's always some expert out there that will come forward and proclaim that he can prove someone is guilty by using this, what I call junk science.
Now, when you refer to defense counsel and, that you really have to be on guard, We also talk about bad lawyering, and, you don't always know what you're going to get. So, is there any way for most individuals who are at the mercy of whomever they get to make sure that their defense will be adequate and on guard for these things?
Yeah, I think the best way is word of mouth. People that don't do a good job in court get a reputation for not doing a good job in court. And I think that if you're faced as an average citizen with a situation where you're being charged with an offense, don't just take the yellow pages. Ask around. And now the other problem is that there are many people who just can't afford the top name lawyer. But my experience has been that there's been actually very many first-rate lawyers who will accept legal aid. Mm-hmm. And again, ask around, and don't feel that you have to take somebody who has probably never done a case in his life, but wants to start involving himself in the criminal law, because there's a lot to know when you're going through disclosure, a lot to look upon as to where this could be misleading, and what you do in court is only the tip of the iceberg to the actual amount of time that you spend in preparing a case.
Yes.
So it's and then of course, the other problem when wrongful convictions come up is that the lawyer doesn't get all the information. Information has been withheld, and that's very serious, and probably isn't found out about till after the conviction. So you can't blame the lawyer for that, but fortunately it's coming about, and there have been some exonerations based on the fact that there has been improper disclosure at the first instance.
There are improvements, I would imagine, or there are more safeguards in place or something. Am I right in terms of disclosure?
Well, again, a lot of it is up to the lawyer to try to discover. Like when I've had cases where things just didn't add up. That there must be something else that leads to this. So again, the lawyer, when he's examining the disclosure and listening to his client, has to be very, very wary of, what else could be involved in this. And sometimes it's just the sense that things aren't right. One of that, and again, I don't like to do it because we like to think of law as a science, but quite often it involves just simple, this doesn't feel right kind of moments for the lawyer. I recall when I was involved with the Association in Defense of the Wrongly Convicted, I was going on a summer holiday down through the Maritimes, and Wynn War, who was involved with the association, called me up and she said, I said, Wynn said, John, I hear you're going down east. Would you have a time to take a day and drive into Renew's Institution and check upon a client by the name of Clayton Johnson? He's been writing to us, and we don't really know what's going on. So I did that. I took a day of my holidays and went to Renew's, which is in the middle of New Brunswick, and miles from anything that you, as a tourist, you would want to see. But I spent the day talking to Clayton and came away with just this feeling that he's telling the truth. And I was able to come back and make a pitch to the association that this guy, I think, has been wrongly convicted. And then they turned their resources to it, and ultimately he was exonerated. So I keep thinking every time I hear the name Clayton Johnson and the fact that he was exonerated, what would have happened if I just came away and from that meeting with Clayton and said, no, I'm probably guilty, and just closed my mind to it, he'd still be in prison.
When you speak about, like, don't go for the lawyer who's never had a case before, but you also talk about this sense of knowing something's not right. Would you say a young lawyer or a new lawyer is just as capable of that feeling, or is that something that, you have to have over time and over experience?
No, I think a young lawyer can do it. Again, it depends on his senses, being able to figure out if things aren't going right and wrong, and not to be bowled over by experience. Like no lawyer would try out this kind of a defense. I recall my very first murder case was in London, Ontario. And it was a fellow who was charged with murder right after Christmas. A young woman had been driven off the road and her throat slashed. And when I was called up by the client, and he was calling me from the London jail, not the jail, the London, Ontario Police headquarters. And he asked me if I would come down and talk to him. Before I was allowed to see the client, I was taken into a police officer's room where he started telling me about what this man had done. And he painted a picture of a young woman who had been driven off the road. And she was closing up shop at a bookstore in London and said, I'll be right home after I feed the bird. I'll be home to join the rest of the family for Christmas. And it was such a compelling story that I thought, how can I ever go in and talk to my client about this? But then it struck me, this feed the bird thing, if that was the case, it would have meant that he would have had to have followed her from the bookstore to her apartment, not knowing whether or not she was going back to St. Thomas, to where she lived. But what would happen if he then had to wait for hours in the cold weather to follow her? And so it just didn't add up. And suddenly when I got to trial, a very experienced Crown attorney never raised in any of the questions to feed the bird. What I was being set up for was to think that this guy was so dangerous that maybe I should just take a plea at the very earliest opportunity and plead him guilty, and everything would be over with. I was being set up by police officers to lead the guy into a guilty plea. And fortunately, I believed my client. And it worked out that eventually he was convicted, but it would have been so much easier and less stressful than going through a trial just to take this lie and turn it into a guilty plea.
All I know is if I need a lawyer, I want one like you. That's all I know. That's all I know.
Well, there's plenty of out there. Most criminal lawyers I've found are exceedingly proficient in doing their job. So I don't think there's any scarcity of very competent professionals out there.
Now, previously you mentioned about misconduct, police misconduct, official misconduct. So we'd love to sort of dive into that a little bit. And obviously there's many areas where that can occur. Is there any one in particular that you would want to lead with?
Well, one of the things that when I was involved with the association, I was asked by Reuben Carter to go down to Texas to interview the governor of Texas, who was then George W. Bush, and the head of the parole board down there. We were trying to secure a 30-day stay of execution for a Canadian on death row by the name of Stanley Falder. Falder, I never got to meet him personally, but the situation was that he was when he was arrested, he was held for over 4 days of intense questioning. And at the end of the 4 days, to get it over with, he signed a confession saying that he had gone in and killed Inez Phillips, a very wealthy old lady who was the matriarch of the Phillips Oil people in Texas, and went to trial. And of course, at the trial, he was obviously convicted because of the use of this confession. Fortunately, he was able to find some lawyers that were able to take the situation in which he confessed to the Texas Court of Appeal, and they found that the confession was involuntary and threw it out. They weren't able to use it. Nonetheless, the Phillips family used private prosecution to again charge him, and then they used his co-accused or person that was with him in trying to set up the robbery of the Phillips home to come in and basically repeat what was in the confession to be used against her. And so again, it was a confession that was put in through the back door through a witness who had something to gain because she was given immunity from prosecution in the murder if she would testify against Falder. It turns out to be quite a remarkable story, and a lot of praise to the lawyers in the United States that were able to follow it through and try to block his execution at every level. Unfortunately, we could only go so far, and the execution proceeded. He was lethally injected. And that had a big weight on my shoulders all the while. Fortunately, in Canada, we don't have the death penalty. I once talked to a young Crown attorney, and he said he would get out of the business if they ever did, because he couldn't stand the emotional strain it would put on trying to invoke a law where the death penalty was involved. Even though I was just there trying to coax a bunch of bureaucrats to accept top-notch Canadian psychiatric evidence that this fellow suffered a psychiatric condition that would make him ineligible for execution under Texas law. Just the fact that they weren't willing to go for it. When Stanley Falder was executed, it was like I had suffered a death myself.
Yeah, I can understand that. I mean, do you think the more we learn and accept about the mind, the more inevitable improvements there will be?
I think so. I unfortunately, we've done a lot of wrongful experiments in psychiatric hospitals with overuse of drugs and barbaric treatment, which the penitentiary doctors have come to grips with. Horrible treatment, not certainly medically sound. Going back to the treatment of prisoners in warlike conditions, it was unbearable. And it's sort of, when you hear stories like that came out of Penetanguishene, they started thinking, is psychiatric route any way to go? But I really believe that people like Dr. Stuart Gracian, the work that he's done in terms of figuring out what happens in solitary confinement, there is progress to be made. And, I just hear so many stories of people who are in for sexual assaults that were sexually assaulted themselves. I'm sure that, I'm sure that a lot of those people could have benefited from psychiatric interventions early on. Yet we look at situations where, and I think mostly of men, because when we think of sexual assault, we usually think of it as being perpetrated by male on female. One of the things we don't understand is that men can be sexually assaulted too. And unfortunately, the ramifications of that in many instances are that he will live out his life getting a fascination because he's never willing to talk about it and try to work out those feelings on others. And really horrible. And if we would start getting involved with childhood victims of sexual assault, I think we could spare a lot of people a lot of hardship down the road.
Mm-hmm. Mm-hmm. And I guess, the point of maybe the legal system is just lock them up, right? As you said before, someone's dangerous, get them out of here. We don't want to see it. We don't want, fear.
Part of the problem is that the public thinks in the criminal justice system, take out the trash, throw them in jail, lock them away. Most people don't understand that the principle that's enshrined in our legislation. Prisoners retain the same rights as the ordinary citizen, save and except as those rights are taken away because of their incarceration. That means that you can't just treat them like trash. You have to try to rehabilitate them, try to find out what made them go wrong in the first place. And I'm surprised the number of inmates that do come successfully through the system.
You're surprised at that?
Yeah, I would think
what
that, Yeah, because I didn't realize that most every inmate can tell you a story of hardship that was wrongfully imposed while they were in prison, and yet what those inmates come out and they understand what they've done was wrong. They understand the impact it's had on society, and they have been able to develop a good release plan for their own self-improvement once they are out. And so I think to some extent the system works, but I'm not totally convinced that we have to do away with prisons. There's people like Clifford Olson and that are just so bad that they require a lengthy stay. I also at one point in time acted for a fellow by the name of Selva Sabaya. Selva Sabaya is probably regarded as the most prolific rapist that ever walked in Canada. And yet he was stabbed in there. I tried to get some sort of compensation for his stab wounds, but he was so hated, and it really wrecked him. And when he came to court, he completely contradicted statements he had said in an affidavit. He didn't have a good supporting corroborative witness. The case was doomed to failure. But I think that in the back of his mind, he felt he was owed that. And again, he never got psychiatric treatment while he was in there, we relied upon deporting him to Malaysia. And so the Malaysian public now has to determine what it will be that will happen to him.
I mean, there's some people who think put them in prison and let them deal with each other. Let them, take care of it internally.
Unfortunately, that's the case, especially for child abusers, rapists, and people who commit those sort of unseemly offenses. There is a con code that it's all right to go in and kill or maim somebody who has done such a dastardly crime. I was just thinking about this recently, where that con code isn't so different to the code that we and the public have about the treatment of these officials, and to some extent what the courts do when they're looking at officials such as their offenders such as that. And there was just a recent case in the Ontario Court of Appeal where a fellow was convicted after a police sting where he met up with a supposedly 14-year-old boy on Grindr. And the problem was he didn't get a lawyer in the first instance. He did have a very excellent lawyer acting as duty counsel at the Court of Appeal level. And at that level, the duty counsel tried to introduce evidence of entrapment, that this was a police sting, that they had lured him into commit, although he didn't commit a crime, they had lured him into a position of internet luring. So the defense he put forward, I think, was brilliant, and it's in the Ontario Court of Appeal decision that just came down in May 2022. So it's well worth a read for anybody that's interested. But on the other hand, the court decides that this kind of behavior is not really appropriate in our society. So they use the principles of our con code society to basically cancel out any ability to use the defense of entrapment and restore his conviction. So I'm really concerned as a retired lawyer now with the way that our courts are really not that different from the way justice is administered inside. And I really am critical when sort of short shrift is given to defenses that should be used. So that's, I've come up with the principle that justice is the legal practice of enforcement of societal norms. And when we talk about justice, we have to first look at what the societal norms are, and then decide whether or not that its imposition is really legitimate, given the laws and the protections that we have. And when we look at it through that lens, unfortunately, sometimes the courts aren't the best answer, because they will tend to enforce societal norms.
Absolutely. When I'm sort of backtracking, unless Kelly, you want to move forward with that? Because I saw you had some reactions to things there.
Oh, no, you're good.
Just this, sort of con code. So prison officials are also involved in that con code?
They know it. They certainly know what the con code is. And unfortunately, they don't do enough to protect people that they know have broken the con code. For example, a newspaper article comes out talking about how a person has been convicted of sexual assault one would expect that immediately they don't have to be advised of the way they now interpret it, that they're in need of protection. I suggest that when that happens, then they should take proactive action to protect the inmate. Yet the other times that will happen is that they will let it be known that a person is a rat, a police informer. Obviously, we need that kind of people to solve our crimes. But by using that procedure, that person is putting himself under dire circumstances that could result in death, because that's against the con code. You don't go to court and give evidence about your fellow inmate.
Mm-hmm. Mm-hmm. And I'm just thinking about, again, going back to court, from all of your years, what and experience is what I mean.
I'm old.
From all of your years, but all of your experience, what do you want the jury to know?
The jury should be told not to just rely on what I guess I was referring to earlier as just the societal norms. They should be approaching this as a judge would, because they are the triers of fact. What is the law, and has the defenses provided in law been made out? And that's often a tough sell to jurors because they like to say let's hammer the bad guy. And the other problem with jury trials is that you don't get to know what's gone on in the jury room. Unlike the United States, where media can interview jurors after the trial, in Canada, it's an absolute offense to speak about what's gone on in the jury room. So when we try to appeal a jury conviction, it has to be on mistakes that the judge has made. And often there has been no mistakes. He's delivered a perfectly fine charge to the jury, and there's nothing that can be found. And yet, when we look at what is justice, and justice is the authoritative imposition of societal norms, it may be the imposition of societal norms that has done the conviction, and not looking at absolute defenses. So I think it becomes very important when we talk to courts of appeal and so forth, that the Court of Appeal should be looking at when has it been that this sort of conviction looks more like it was the result of trying to, as I said before, take out the trash, than provide a balanced weighing of the facts and the law.
And just so I'm clear, do we all know what societal norms are? Is this, there's the book.
They're changing all the time.
Okay. So I can't just go look that up right now.
No. And in fact, when, just think about in the 80s, when Terry Fitsimmons first started out, there was a real societal norm against gays, gay marriage, and yet today, hey, that's not normal. We all know people like that, and we live and perhaps have them in our family. So it's not something to be ashamed of anymore. But back in the 80s, having AIDS, and that was considered a killer disease back then. So it's a norm that really was used to shame people. In the Terry Fitsimmons case, Terry and his partner were referred to as Canada's gay Bonnie and Clyde. What effect did that have on an inmate who had to then go back into a prison, and with that kind of a label being put on him? So that's a situation where today nobody would care. Back in the 80s and early 90s, that was very much in the forefront of somebody's mind, and it's a situation that he has to live with, both in working his day-to-day activities on the street and what will happen to him once he gets back into jail.
Yeah. It's that perpetual position of you don't know what you don't know. So
exactly.
The 80s, very different time. Yeah, in all of these cases. I'm kind of fascinated, maybe a bit off topic, but what it would be like to sit down with someone like Clifford Olson. I'm sure you've been asked a million times.
Yeah, my very first experience walking into Clifford Olson's cell was that, first of all, I'd never seen Clifford Olson except in his photograph in the paper. I thought he would be a big guy. In fact, he was pretty small. And the other first impression I had of him was, this guy is absolutely charming. He was able to talk to me as though I were an old friend and really lure me into a position where I felt that I had his trust, and he could talk to me about anything. And as I point out in my book, I didn't really know how to react on this. And so I commented to Clifford. I said, I can see why the young kids that you killed could be raped and killed, would be totally comfortable meeting up with you. And then he just turned. He became very angry, and you could see it on his face. He says, I never raped any of them. He says, I waited till their back was turned and then buried a hammer in the back of their head. And I thought, my God, this is pretty gruesome for somebody just to come out and admit. And then I later found out that in talking with another writer, Clifford had bragged about how he had raped these people. So you couldn't believe a word he said. It was whatever fit in the context of what he was talking about. And there's so many of these people that have this wonderful charm and believability. And then you find out that really they are psychopaths and can't be trusted.
Can you identify it? Like, do you feel like if you've sort of met enough of them that you can be like...
I can't identify it, but I can have my senses awakened when somebody comes on and is that charming. And so I just no longer simply believe everything they're telling me.
Mm-hmm. I was going to say, like...
he contacted me. He asked me to go to San Francisco because he had lured Melvin Belli, who was a San Francisco trial lawyer, into believing that he, Clifford Olson, was the Green River killer. And I took some vacation time and drove up the Pacific Coast Highway from Los Angeles to San Francisco.
You like to give up your vacation time.
Yeah, always. I went into Melvin Belli's office and met up with his researcher. And the researcher said, "Oh, we're not doing that case anymore. We found out that it was all lies that he told us. He had gotten minuscule details out of several books that had been written about the Green River killer and had strung them together to make a plausible story. And but fortunately, there were good researchers on Melvin Belli's behalf that spotted it and understood where Clifford Olson was coming from. He wanted to be known as the biggest child killer it would have brought his killings up to 60, and that he thought would horrify the public enough that he would be remembered for all time.
How do you balance or wrestle that understanding of the whys and having compassion for individuals, because there are reasons typically with someone who you maybe can't even, you despise maybe?
Well, I didn't have a lot of good feelings for Clifford Olson. But on the other hand, he's a human being. He may have psychiatric problems that will make sure that he's probably in prison for the rest of his life. But when I was contacted just before his death, I was asked about, am I glad that he's going to be done on his deathbed? And I had to say, no, as a human being, he has the right to life and to be given the most appropriate medical treatment until he eventually succumbs from his disease. I couldn't, even knowing what I knew about him, I couldn't say, no, take him out.
Mm-hmm. Yeah. Love that. I have a couple more questions. Kelly, do you have anything at the moment?
No.
I know you're just listening.
No, not currently.
So John, tell us a little bit more about your book, sort of why you felt it was time to write it, and also the subject matter being that there's misconduct involved. So a little bit about that.
Okay, well, I used my pandemic time to good use. I couldn't go out, so I sat down at my computer and started telling about the stories that other people had, seemed to be fascinated by when I would tell them about them in other occasions. So, okay, well, let's sit down and see if I can put them ink on the paper and get the story out that way. Terry Fitsimmons' story was one that seemed to be resonating with a lot of people, that they didn't understand how somebody who grew up in a middle-class neighborhood in London, had all the accoutrements of a good upbringing, could turn into the monster that he became. So the story in the book, I tell the ending first, that in 1995, guards in Kingston Penitentiary came down and found him hanging from a rope he had done himself in. Terry didn't really want to live, but he wanted his story to be told. And I think that sort of came on me, not initially while I was going through the process, but later as I thought back upon it and thought about the number of times that he said, people have to know what goes on. I think that Terry was almost being a martyr, wanting his story to come out, that solitary confinement is so evil that it puts its evil in everybody that it touches. And so the book is called Box Parole, Terry Fitsimmons and the Quest to End Solitary Confinement. I've also have some other stories in it, ones that I've talked about somewhat here. But the main story is about Terry Fitsimmons. And I was quite surprised that when I tried to share the story, am I making mistakes? I sent it out to some people that I respected and wanted their take on. So as a result, Raphael Rowe, who is the British broadcaster who spent 12 years in prison himself, and he's now the host of the Netflix series Inside the World's Toughest Prisons. He read it and liked it and agreed to write a foreword for the book.
So is there a case, looking back, that you wish you could have defended?
No, any case that I can think of that has been done well, I really appreciate the lawyers that have been involved in it.
Is there anyone that you think I would have done that way better?
The case that I was just referred to earlier is a case just recently decided in the Ontario Court of Appeal called Stack. And it was a fellow who was subject to internet luring charges. He had a tremendous lawyer acting as duty counsel at the Court of Appeal. What I wish it would have had is a lawyer at trial, because he basically lost because the Court of Appeal wouldn't listen to the fact that new evidence or a new defense should be raised on appeal. The Court of Appeal threw out what brilliant arguments that his lawyer at the appeal court raised, and just said, "Oh well, too bad. It should have been raised at appeal or at trial." And it's really unfortunate, because I think an injustice was done. And unfortunately, our courts tend to think upon the rights of the child as supreme, another one of our social values that we cherish. And that comes at the expense of a legitimate defense of entrapment.
Mm-hmm. You said you had a list, and of course we cover all of the system flaws that can cause wrongful convictions, and very often it's not just one. It seems like there's a bit of a stack that can occur in any given cases. Was there anything incomplete about what you wanted to contribute?
Well, the only thing is that, again, I think that a lot of we talked about public pressure being a driver for incarceration. One of that I think a big injustice has been done is to Inderjit Sigh Reyat, who is commonly known as the only man convicted of the Air India bombings. And when you look at his case, he pleaded guilty to his involvement and received a $2,000 fine. Then was the use of informants, the public harassment that he got from victims groups, that the government was actually forced to put him into positions where he would have to plead guilty to manslaughter charges and so forth. And yet, in all the subsequent convictions that were made, he never said anything more about his involvement than he did in his original trial, where he was fined $2,000. So he ended up spending 30 years in prison for something that he had already been fined for doing. And yet, when Malik was gunned down in Vancouver, we never hear the public or the victims raising questions that, maybe somebody was wrongfully convicted, or at least did a lot more time than he should have done, because public pressure. Again, we can't have people that get involved, or even know people who get involved with bombings, walking the streets. So I think that was a case that I really feel that there was a miscarriage of justice. Ultimately, I talk about it in my book as well. So it's my book is really not written, I think, as somebody who has been involved in the criminal and prison justice system for so many years, how great the system works. I think that it doesn't work. And to some extent, we are called upon to cover up the mistakes. I think that what my book will do, if anything, is try to call out to people that there's a fight going on right now, and the fight is for justice and proper treatment within our prisons and in our criminal justice system, and just ask people to get involved in it.
Absolutely. Absolutely. If you could, we could snap our fingers and you could have, exactly what you want happen in all of your experience. If we could say, okay, done, that improvement can be made. Is there something that you can think of that you would?
Yeah, right now, I would say the biggest thing that could be done, at least in Ontario, is proper funding for the legal aid system. We've been subject to cutbacks. There's been changes to the system so that, and in fact, they're even presenting a system where lawyers will get block fees for pleading people guilty. It's a travesty that this should be what it was designed to do, and that would be to give people that can't afford it proper representation. And I would even go so far to say lawyers should be required to do some cases on legal aid, much as people are saying that they should do pro bono work. And there should be proper funding for the whole system and not constantly looking for cutbacks. It's we could have a great legal system, but it requires funding. Mm-hmm. And unfortunately, one of the major sources of funding is always subject to governmental cutbacks. And it gets away with it because, hey, we don't want to spend money protecting criminals. Again, going back to the societal norm.
So just this idea of, okay, like I need a criminal defense lawyer. Mm-hmm. I pick up the phone. I'm hopefully not choosing the first one in the yellow pages or the first one on Google, maybe. I don't know. So I call you. What happens?
I suppose what I would do is I would take down your contact information. I would ask you about if there've been any charges that you're concerned about. I would not ask you on the phone about any of the situation. And I would ask you not to talk to anyone about your situation while we're on the phone or later until we have a opportunity to meet. On the first meeting I would set up, I would no doubt talk to you about retainer, whether or not this would be a legal aid matter or whether it would be privately paid for. I think it's important that people come to grips with the fact that there are expenses involved, and we have to have some sort of knowledge of how that's going to come about. Assuming that would be raised, then I would also talk to you about what you've told the police already, what other people might be telling the police, and what your story is. And then, depending on that, I might have to schedule follow-up interviews with other people, with other doctors, and find out just what was available. And then once I agreed to take on the retainer, I'd ask you to sign a retainer agreement, and then probably start then doing the applications for disclosure from the Crown Attorney. And then, of course, as you get through more of the case, require follow-up interviews. If you're on bail or about to go up for bail, you would want to know who your sureties would be. and whether you would be amenable to conditions that might be imposed if you were granted bail. So there's a lot of little technical questions at the start, but they're all important, and it's not looking for the big picture at the front end. It gets into looking at a very precise area of law, what you're involved in, and then what the lawyer would have to do even at that preliminary stage is start to weed out what is in irrelevancy in order to come up with what we call a theory of the defense. And once you form the theory of the defense, it gives you a great big railroad right into the heart of the matter. And now it may be that you have to change trains as you're pursuing it, but it's very important that if you don't have a theory of the defense, and this is what I've seen some inexperienced counsel do, they go to trial and they're all over the board. And things that might be really necessary to talk about, especially in front of the jury, they get messed up. They lose their focus. So building the theory of the defense, I think, is the most crucial part of a criminal defense.
How likely is it that I've said I'm innocent at some point to you?
Very, very likely. And chances are you might be. But that really doesn't matter to the criminal lawyer because if you're guilty, then the idea is to get you the best possible outcome. And that should be explained. I think it would be inappropriate for a lawyer to say, you're going to be acquitted. And then you lose. So every lawyer tricks himself into thinking that the client is innocent. But the idea is for the client to be upfront with the lawyer. And we don't want surprises at trial. It
is to everyone's benefit, anyone's benefit, to be
that's right.
absolutely honest.
If you say things that might incriminate you down the road, the lawyer is bound by solicitor-client privilege. That's your privilege. You're the only one that can waive it. The lawyer has to continue on and never mention that to a soul. The only stickler is that if you told the lawyer you're guilty, then the lawyer cannot go and put you on the stand and claim your innocence. So there is a bit of a downside because a lawyer cannot perpetrate a lie on the court. So if you said that, it may be limited to some extent, but it's also very important for the lawyer to know the truth.
Mm-hmm. Mm-hmm. Wow.
So can I just ask a variation of that question? So, presumably Kelly's never had contact with a criminal lawyer. She's calling you for the first time. She needs a defense. Is there like a checklist of questions that one should ask for them to know that they're getting someone who knows what they're doing?
I suspect so. I think that will probably come if you're at all logical. If you've never been involved in the criminal system before, do you specialize in a particular area? Have you done trials like this before? What do you think would be an outcome in a case such as mine? So basically not for the accuracy of the information you get, but to give you a feel for whether or not the lawyer knows what he's talking about.
No, that's great. That's great. Because, if you say, what are some outcomes, and they give you something that seems too good to be true, probably you're speaking with someone who, exactly. You're probably speaking with someone who's not quite sure what they can and can't deliver. So, no, that's good. Of everything that you've done in, your years of practice and everything that you have experienced, what's the take-home message?
Well, I guess the take-home message for me would be not one that's really positive. I think there's a lot of mistakes in the system, and a lot of mistakes not only in the court processes, but in the prison processes. And it's important for people to realize that our justice system right now is imperfect, and for a call to all of us to get out and try to improve it.
Wonderful. Yes.
I think that is the perfect take-home message for our podcast.
Yeah, it's great. We'd like to thank our guests for their insight, stories, and expertise. And we'd like to thank you, our listeners, for your interest in the world of wrongful convictions and for sharing our podcast. For more information on wrongful convictions, visit our website, realliferongs.com, and email us at hello@realliferongs.com. You can find us on Twitter, LinkedIn, Instagram, Facebook, and anywhere you find podcasts.
All of us could falsely confess to something.
They blew it all out of proportion, and they got away with it.
Even a country like Canada has people who are charged and convicted of crimes they didn't commit.
There's innocent people who are going to die in prison.
I can't get back the time that they took from me.
And I was just left wondering, what the hell is happening?
I knew my life was over right there. That's when my life ended.
They're changing the story that I told them to match to what really happened.
I was just incarcerated for 37 years for somebody else's crime.
That what happened to me could easily happen to anybody.
Real Life Wrongs is produced by Kelly Fanson, edited by Alex Clutch. Promotional materials by Jamie Norrie.